to be entitled to the relief sought. The case of the claimant who worked for the first defendant as a teacher from 1st June 1999 until her retirement on 15 November 2016 is that the consultant under the supervision of the first defendant refused to include her name on the pension nominal roll for payment, even after obtaining clearance from the governor's office annex and from pension directorate, pension unit of the Ministry of Finance, and that she is yet to receive her pension since November 2016 till date. It is the further case of the claimant that her predicament was compounded by the appearance of the second defendant as a fake Erit Okon Ogbong, whose maiden name is Agnes Wei Owong, sorry. Now the burden is on the claimant to prove all these assertions to be entitled to the relief sought, and because she is the one seeking for judgment on the existence of these facts, the burden of proving the existence of those facts rests with her. In other words, he who asserts must prove. See the case of Buhari and Obasanjo, Bayelsa and Rivers, Womilojo and Anibere, and Ikwebu and Nigeria. And these propositions are also the purport and tenure of sections 31, 32, and 33 of the Evidence Act. There is also the requirement that the claimant must do so on the strength of his own case and not on the weakness of the defense, subject to some exception. See the case of AIC Limited and NMPC and Abimbola and Abatan. The claimant thought to prove her case by both oral and documentary evidence. In her oral testimony in court, the claimant maintained that she was employed as a teacher by the first defendant on 1st June 1999 and retired from service on the 15th day of November 2016. That the first defendant failed, refused, or neglected to payroll her as a pensioner upon retirement from service, resulting in the non-payment of her salaries and pension till today. That the second defendant, who is impersonating her, made it impossible for her pension and gratuity to be paid by the first defendant. To support the above assertions, the claimant tendered and relied on 10 documents as exhibits. That is Exhibit CW1 to CW10. Only the pertinent exhibits will be considered here. Exhibit CW1 is the offer of appointment dated 1st June 1990. 4. Exhibit CW2 is the notification of appointment and upgrading of the claimant dated 22nd January 2001. Exhibit CW3 is the confirmation of appointment dated 12 May 2010, effective from 1st June 1996. Exhibit CW4 is the notification of retirement from service dated 18th November 2016 as a senior master mistress, stroke, effective 15 November 2016. Exhibit CW8 is a letter of demand for the payment of pension dated 10th November 2017 from UA Onu and Associates. Exhibit CW9 is the letter from the Methodist School, Oruko, dated 20th November 2015, recommending the payment of the claimant's salaries leave grant to Skybank PLC. Exhibit CW10 is a letter from the Education Secretary recommending the claimant to be payrolled dated 20th November 2015. The combined effect of this exhibit is not only to prove that the claimant is a bona fide employee of the first defendant, but who retired from service but remained non-payroll and therefore not paid pension and gratuity till death. The same cannot be said of the allegation of the impersonation of the claimant by the second defendant. The claimant did not present any document in support of her several affirmance in that regard, and the allegation have been disputed by the second defendant. The oral evidence of the claimant remain unproven as affirmance in pleading as affirmance in pleading without evidence goes to no issue. With this, the evidential burden has shifted to the defendants to prove otherwise, beginning with the first defendant. In her defense, both through her witness as well as submissions, the first defendant placed the responsibility for the alleged non-payment of the claimant salaries and pension on the doorstep of the claimant. The first defendant recounted how the claimant was not migrated to the database because she was not captured along with other teachers in April 2015 for the claimant failure to sort out her difference with the teachers capturing committee. It is in evidence that the teachers capturing committee in April 2015 commented that, and I quote, employee, that is the claimant, should have retired since this evidence was shown in the Northeastern State newspaper publication of change of name. Thus, the claimant only provided letter of appointment of 1994 from LEA Oru Ofong Okoro, end of quote, and thereafter demanded for further clarification, which the claimant failed to give. According to the first defendant, the refusal by the claimant to go back to the committee with the documents specifically requested by the committee was self-inflicted, and the claimant could not be heard to complain because of the maxim volunteer non-fit injuria. As a defense, the first defendant is only stating it was not responsible for the failure to capture the claimant by the committee and seeking to absolve itself from liability. In other words, the first defendant is not disputing that the claimant was not captured or not paid her pension. So for all intent and purposes, the allegation of not being payrolled and non-payment of pension remain intact. The same goes for the evidence of the second defendant. Both in oral and documentary evidence, the second defendant did not allude to the right of the claimant to pension and salaries, but concentrated in exonerating herself from the allegation of impersonation leveled against her. A pointer to this can be seen from all the documents tendered by the second defendant at exhibits DW21 to DW27. On the preparedness of evidence, I have no hesitation in finding and holding that the claimant has proved her case to be entitled to the claim and release sum, particularly when pension is an accrued interest of an employee, be the right in money or other consideration on retirement, which cannot be taken away. See the case of Mahmoudou and Nolge and Nepa and Adeyemi. Relief C and D for injunction restraining the second defendant from further impersonating the claimant, and general damages in the sum of 3 million cannot, however, be granted. Relief C is the subject of counterclaim and will be considered unknown, while with the success of Relief A and B, Relief D will amount to double compensation. See the case of Majambi and Otto, Ogu and General Oil, Alhaji Mustafa Aliu Kusa, and United Power Construction, to the effect that once a party has been fully compensated for the loss or harm suffered, it will not be open to court to proceed to award him any other kind of additional damages that may look like a bonus. We are now left with the second defendant counter claim, praying for one, a perpetual injunction restraining the claimant, husband, heir, and anybody from her side from further false publication against her or further libelous of publication that she is fake Arid Okono and also Agnes Uwe. Two, a perpetual injunction restraining the claimant from further false publication that she was illegally employed in the service of the first defendant. Three, the second defendant claimed a sum of 5 million only against the claimant for libelous publication against her at the first defendant's office in Uyo, State Police Headquarters, Ekot Apang Mabia, Independent Corrupt Practices Commission, and for causing her psychological trauma, public audience, financial stress in appearing before the statutory bodies herein mentioned and the court. A counter affidavit for all intents and purposes is a separate, independent, and distinct action, and the counterclaimant must prove his case before obtaining judgment on the counterclaim. See Obuna and A.G. Mosted, Ogbamini, Briggs and Stone versus ACB, Dabob and Kola, and Eric and Union Bank, to mention but a few. The law is that the second defendant, that is the counterclaimant, have the burden of proving their entitlement to the reliefs. I've earlier held that the claimant did not prove the allegations against the second defendant, and that would have ended the matter, but for the spirited effort by the second defendant to exonerate herself by tendering 7 exhibits. That is DW21 to DW27. Exhibit DW21 is the first living certificate. Exhibit DW2 is the National Teachers Grade 2 certificate dated 1st July 1999. Exhibit DW23 is the National Teachers Institute certificate Kaduna. Exhibit DW24 is the letter of appointment dated 17 May 2001. Exhibit DW25 is the confirmation of teaching appointment dated 12 November 2008. Exhibit DW26 is the statutory declaration of age dated 26 July 2000. Exhibit DW27 is the certificate of identification or origin dated 28 August 2000. The combined effect of this certificate is to show that the second defendant from birth bore the name with which she was employed. In the same vein, the document goes to support the assertion by the defendant that the board has at no time mistaken the claimant for the second defendant, since their rank, entry points, years of appointment and salary, and grade levels are absolutely different from each other. On her part, the claimant in her reply to the second defendant's statement of defense and counterclaim reiterated her stand and proceeded to inform the court: A, how the second defendant refused to attend screening when it was discovered that two of them bear the same name. B, the inauguration of the first panel by Pastor Praise Okon, who was the permanent secretary, Subeb, then headed by Mrs. Amaya Akpan as head. C, the inauguration of the second panel by Musa Ezekiel Umo, permanent secretary, headed by Okon Asuku Suwanga. It's a long time I left Uyo, so
as accomplices.
With three other members. D, the police at the state CID never concluded investigation and the matter was transferred to ICPC, after which the claimant was paid 3 months' salary in lieu of retirement. While the evidence of the counterclaimer only shows the consistency in the use of her name, it does not entitle her to the relief sought, which are predicated on the thought of defamation with its attendant stringent requirements. It was Akintan, Justice of the Supreme Court, who in the case of Oliobachi and Oliobachi, who gave the ingredients a plaintiff must prove to succeed in defamation. And I quote, the law is settled that to sustain an action for libel, the plaintiff must prove 1, the publication was in writing, 2, the publication was false, 3, the false publication was made to a person apart from the plaintiff and the defendant. 4, the publication referred to the plaintiff and was defamatory of the said plaintiff, and the publication was made by the defendant. He referred to Din and African newspapers, Oyejike and Ayaso, Nizrim and Oluan Agbese, end of quote. See also the cases for Oluge and New Africa, Econ and Otop, and Skybank and Hakim Pelu. Applying the principles to the facts of this case, it cannot be disputed that the counterclaimant cannot bring her case within the realm of defamation by a long shot. To start with, no precise word of label alleged in writing was tendered in evidence, not to talk of any publication. That being the case, it is tried law that an action for libel cannot be sustained without proof of publication. See Nizrim and Nizrim, Mamman and Salahuddin. Assuming but not conceding that the claimant action is reporting her alleged impersonation by the second defendant to constitute authorities, the police, embarking on court action, constituted publication, the claimant will definitely enjoy the defense of qualified privilege. Refer to the dicta of Onogen, Justice of the Supreme Court as he then was, now retired Chief Justice of the Federation, in Mamman and Salahuddin, and I quote, classes of statements which have been held to constitute privileged occasion include the following. A, statement made in the discharge of public or private duty. Statement made on a subject matter in which the defendant has a legitimate interest. Statement made by way of complaint about those with public authority and responsibility. Report of parliamentary proceedings. Copies of or extract from public registers. F, report of judicial proceedings. See Gadley on libel and slander, 9th edition, paragraph 14.4. From all I'm saying, the counterclaimant did not succeed and is hereby dismissed for lacking in merit. The case of the claimant hereby succeeds, and it is hereby declared that the failure, refusal, and neglect by the first defendant to payroll the claimant as a pensioner upon retirement from service of the first defendant is most unjustifiable, illegal, null, and void. The first defendant is hereby ordered to payroll the claimant forthwith as a pensioner and to defray all arrears of salaries and pension owing to the claimant before and from the month of disengagement from service of the first defendant, being 15th November 2016, till judgment and subsequently till death. I make no order to cause judgment entered accordingly.
As accomplices, Lord, we are so grateful for this judgment. We are very grateful.
I must say,
thank you, my Lord. We are grateful.
All the spirited effort of Sharon. She did
My
not
Lord.
in any way.
She did her best. I commend her.
You know, sometimes it's the facts that determine the case.
That's true, my Lord.
Yes, sir.
But well done, all the same.
As accomplices.
Mm.
We are grateful,
Thank you, my Lord.
Thank you, my Lord.
Thank you, my Lord.
Sharon, good luck.
Call the next case. Call the next case. Bappa, you have muted yourself.
Hello. Case number 2, NICN slash 2022. Between Elder Dr. Joseph O. Eleza versus 1 Italy, Nigeria Limited. Second, Lipo Dean.
Did you say the claimants are here? Appearance? They are not here.
They are not here, my Lord.
The parties are also not here.
Yes, my Lord.
I think so, my Lord.
So I will just have to read my judgment the way it is.
Okay, my Lord.
I have taken time to consider the facts of this case as given in the various processes, the evidence and most of the authorities thereof, and I think the issues submitted by the defendants, which are similar to the claimants, are enough to determine this suit one way or the other. To wit, 1, whether the claimant has proved his case to be entitled to the relief sought by him. 2, whether the defendants have proved their counter claim to be entitled to the relief sought therein. Before the determination of the above issue, there is the need to consider the application to strike out the name of the second defendant for failure to disclose any reasonable cause of action against her. Without the necessity of recounting the argument of the parties on this issue, I can straight away refuse the application. The reason is simply because the interests of the defender are the same or identical, and therefore sit well with one of the guidelines proffered in the cases of Karena and another person, Orolo, Adeniran and His Royal Highness Oba Ibrahim, and the case of Gasol and Purare, where the consideration was whether the judgment will affect the other party. Who is disturbing proceedings? Now is the time to consider issue one, whether the claimant has proved his case to be entitled to the relief sought. Generally, the burden is on the claimant to prove his case and that he is entitled to all the relief sought because he is the one seeking for judgment on the existence of facts which he asserted. In the case of Buhari and Obasanjo, Bayelsa, Rivers, Uhuru, Jami, and Ebri, Ikwebu and Nigeria, but whereas in this case, the employer gives reason or cause for the termination, the law imposes on the employer the duty to establish the reasons to the satisfaction of the court. See the case of Shell and Olariwaju, Institute of Health, and Naim, where Chukuma Ene put this succinctly, and I quote, although it is tried that an employer is not obliged to give any reason for firing his servant, all the same, it is settled that where he has proffered any reason at all, it is obliged to satisfactorily prove the same as the onus is on him in that regard. Otherwise, the termination or dismissal may constitute a wrongful dismissal without more. The reason given by the first defendant for the determination of the claimant appointment can be found in Exhibit CW2. And I read, in accordance with Clause 4 of the Irrevocable Management Agreement, in case of proven misappropriation as mismanagement, the contractor reserves the right to terminate or remove the project director from his position. This letter will serve as notification that, pursuant to the provision of the above referenced agreement, you are being relieved of your assignment as a project director with the company, effective from 14th day of December 2021 as a result of misappropriation of funds, embezzlement, failure to account for monies entrusted in your care, and mismanagement of company assets. Kindly submit all company's document, equipment, and any other thing in your possession to the company secretary as you vacate your office with immediate effect. Thanks in anticipation of your cooperation. Signed by Lee Ping Ding, Managing Director, Chief Executive Officer. Under the circumstance, the onus is on the defendants to prove not only the allegations against the claimant, but also that his termination was in accordance with the irrevocable management. See the case of Management Board and Atiga, where E.O. Ayola put it thus, and I quote, the law is also tried that why a person, body, or authority claims to have acted pursuant to powers granted by statute, such person, body, or authority must justify the act if challenged, by showing that the statute applied in the circumstance, and that he or it was empowered to act under it, end of quote. The task before the defendant is therefore to prove that the appointment of the claimant was terminated for misappropriation of funds, embezzlement, failure to account for monies entrusted in his care, and mismanagement of company assets in accordance with the irrevocable management agreement, that is Exhibit CW1. To prove the allegation of misappropriation of funds, embezzlement, failure to account, entrusted in his care, the defendant relied on Zenith Bank account numbers 101-865-7783, that is Exhibit DW2, and number 101-7824-632, Exhibit DW1, belonging to the first defendant, in which the claimant was the sole signatory and joint signatory, respectively. Apart from giving impetus to the pleadings or averment in the joint statement of defense, these two exhibits have the advantage of justifying the allegation against the claimant in the manner following. One, the first defendant has paid over 6 million, 6.1 million into the claimant assets account number 0689-520202 between the 4th September 2019 and 14th February 2020 for rent of the office and other sundry needs. Two, on the 18th October 2021, the first defendant renewed his rent by paying the sum of 2 million via Zenith Bank PLC account number 01-865-7783 to the landlord for its office. Three, the claimant, without approval and for no benefit of the first defendant, diverted the sum of 25 million 25,500,000 naira into his Access Bank account number 08689-520-202 on the 13th October 2021. The claimant also diverted the sum of 5.7 million on 13th October 2021. The claimant paid himself the sum of 8 million naira in his Access Bank account on the 14th October 2021. The claimant diverted the sum of 2 million into his account on 13th October 2021. The claimant took the opportunity to divert the first defendant's money to his private account and those of his cronies without defendant's approval or consent. Under the circumstance, the defendant reserved the right to terminate or remove the claimant by virtue of Article 4 of the Irrevocable Management Agreement, that is Exhibit CW1. There is nowhere in the management agreement where the claimant must first be queried or tried before his appointment can be terminated, most especially in the face of the obvious facts and the claimant has misappropriated the funds of the first defendant. I have therefore no hesitation in finding that the defendant has so far proved the allegations against the claimant. With this, the evidential burden has shifted to the claimant to prove otherwise. In denying the allegation of misappropriation of funds, embezzlement, and failure to account for monies entrusted in his care and mismanagement of company assets, the claimant relied on 28 exhibits marked Exhibit CW1 and 28. Exhibit CW1 is the irrevocable management agreement, which not only shows the employment relationship between the claimant and the defendant, but assists in proving that the defendant did not prove the allegation against the claimant before the termination of his appointment. Exhibit CW2 is the letter of termination, where the allegation and reasons for the termination of his appointment were provided. Exhibit CW6 is the irrevocable consultancy agreement, which entitles the claimant to a fee of 5% of any contract secured by the claimant for the defendant. Exhibit CW7 is the letter of award of the contract for the construction of 1.6 kilometer road to the first defendant, purportedly secured by the claimant for the first defendant. Exhibit CW8 is the memorandum of understanding between the government of Akwa Ibom State and the first defendant for the undertaking of development projects under the alternative project funding approach. Exhibit CW 4 and 5 are the claimant access bank accounts, while Exhibit CW 9 to 28 are cash invoices in respect of the expenditures by the claimant on behalf of the defendant. The combined effect of Exhibit CW 4 and 5 and CW 9 to 28 are not only to give impetus to the reply to the joint statement of defense, but to explain away the allegation of failure to account for monies entrusted in the claimant care and mismanagement of company assets in the manner following. One, that the transaction marked green and pink in Exhibit CW4 and 5 respectively for the claim of 19.7 million being expenses for payment of rent renewal and hire of equipment which were never refunded by the defendant. Two, that the said 25.5 million alleged by the defendants who have been diverted was payment made to the claimant with the approval of the second defendant and his consultancy fees of 5% of the 510 million contract. Three, that the 5.7 million was made to Ibrahim Dairu as repayment of the loan earlier given to the first defendant for the purchase of asphalt and other construction materials. The said payment was made to the claimant to be remitted to the said Ibrahim, and same was approved by the second defendant. Four, that the 2 million was withdrawn on the specific instruction and request of the second defendant for public relations, and the said sum was withdrawn by the claimant and handed over to the second defendant for the said public relations. Five, that the 8 million was arrears of salary paid to the claimant for the months of February 2001 to February 2021. Six, that the 6.1 million claimed by the defendant to have been made for rent, while some made for the setting up of the office quarters in Uyo, the payment of rent for the period of November 2019 to October 2020, payment of commission stroke fees to agents for the said property, furnishing of the office and quarters, hotel bills and flight fares for both the claimant and the second defendant, and the renovation of the said office complex, all of which were approved by the second defendant. To justify the claim for the salary of the remaining 9 months, 9 years and 1 month. The claimant relied on clause M of the exhibit CW1, which gave the employment of the claimant a duration of 10 years set and the case of Dangote Cement and Aga, to the effect that wrongful termination of the claimant employment without recourse to the terms of the said contract is a breach of same, and the claim for the salary for the remainder of the period is an appropriate claim in the circumstance. On claimant arrears of salary of 3 million for the 3 months, the claimant relied on the submission of the defendant that if the claim is true, the claimant would have paid. The claimant who was in control of the account ought to have paid himself. The claimant also used the irrevocable management agreement and the letter of termination, particularly paragraph 4, which was restated in exhibit CW2 to stress that the allegation of mismanagement or misappropriation is to be proved before the employment of the claimant can be terminated, when in actual fact, he was never confronted with any of the allegations. Similarly, the defendants have not placed anything before the court to show that prior to the said termination, the claimant was queried or even asked to account for the monies they claim was embezzled or misappropriated. The claimant also described the evidence of DW as hearsay evidence and therefore inadmissible, since the witness admitted not knowing the members of the board of directors of the first defendant and the fact that he never supervised the claimant. And given the nature of the employment, which is master and servant, a termination of employment to be lawful must be done in accordance with the terms of the contract of employment. And where termination is not in accordance with the provisions of the contract, the termination is wrongful and a claim of breach of contract will be sustained as bound by the terms in the cases of registered trustees, PPFN, and Shokbola, Natel and Ocholi, Oak Pensions Limited versus Olayinka. From the foregoing, the claimant discharged the essential burden shifted on him to dislodge the finding and holding that the defendant proved the allegation of misappropriation of funds, embezzlement, failure to account for monies entrusted in his care, and mismanagement of company assets against him. In other words, on the preponderance of evidence, can it be said that the claimant has proved his case to be entitled to the claimant relief sought? I think not, and for reasons easily discernible. In the first place, all the exhibits tendered by the claimant did not dislodge the allegation of misappropriation of funds, embezzlement, failure to account for monies in his care, or mismanagement of company assets against him. Exhibit CW9 to 28, which seeks to exculpate the claimant, did not have the signature of the second defendant to give semblance of any approval by the defendant to the expenditures, as the claimant wants the court to believe. There is therefore force in this contention of the defendant that the claimant failed to debunk the fact that he mismanaged the money under his control and that the cash receipt failed to link the receipts to any item he claimed he purchased for the defendant. Closely connected with this is the fact that all cash receipts do not have any working documents to support them. Some of the payments are to subcontractors, and there are no subcontract agreements, job orders, or invoice to cover the transaction or payment. The most glaring of it is section CW10, the cash received invoice in the sum of 5.7 million for the payment of asphalt by one Ibrahim Dairu into the account of the chairman without any explanation. All the foregoing are indication of mismanagement and lack of accountability alleged. I have also observed that most of the questionable payments covered by the unsupported cash received invoices were made from the first defendant's Zenith Bank account number 101865778, in which the claimant is the sole signatory. The reliance by the claimant on the irrevocable management agreement exhibit CW1 in both the duration of the employment as a period certain and proof of the allegation before determination is of no moment and is of no assistance to the claimant. I agree with the submission of the defendant that there is nowhere in the revocable agreement stated that the claimant must first be queried or tried before his appointment can be determined in the face of the obvious facts that the claimant has misappropriated or mismanaged the funds of the first defendant. The introduction of the powers of the contractor to terminate and remove the project director on misappropriation or mismanagement has effectively cut short the 10 years certain of the contract agreement. In the light of the foregoing, and on preponderance of evidence, I have no doubt in finding and holding that the determination of the claimant from service on the allegation of misappropriated or mismanaged funds was well-founded and proved to the satisfaction of this. The feeble attempt to put the facts of this case in the realm of crime so as to ensure proof beyond reasonable doubt is a non-starter. This is because the case is not founded on crime in spite of the use of strong words such as misappropriation, embezzlement, and mismanagement, etc. See the pronouncement of A.I. Abu, Justice of the Supreme Court, in the case of Arowolo and Ifadei. And I quote, I need perhaps add in the above regard that while a strong language is employed to describe one's conduct or motive in a transaction as was done in the present case by the use of words fraudulently, that does not ipso facto convert the basis of the claim to a crime. See Godwin Awankwere, Joseph Adeu. I therefore entertain no doubt that the standard of proof required in the present case must be the balance of probability or preponderance of evidence and not on the basis of proof beyond reasonable doubt as provided for under Section 1381 of the Evidence Act. See also the case of Imoneke and Unity Bank, where Oregon Justice of the Supreme Court, as he then was, said, and I quote, in the instant case, I have to repeat that having found as a fact that fraud used in this case is not that with criminal law flavor, but for general use, it follows that the issues for this issue of standard of proof of same, that is, of proof beyond reasonable doubt, does not arise at all. I also held that as regards the general sense in which words fraud, dishonesty are used in Exhibit P18 and other related documents in the case, the mere issue of queries and replies there without more discharge the obligation on the respondent, particularly as the respondent can thereby be satisfied or not satisfied with the explanation offered by the appellant. In other words, the standard of proof applicable to the fact of this case is that of balance of probability. I hold the view that the above holdings earlier made the present issue irrelevant. End of quote. With this, the declaratory reliefs A and B must fail. Relief C in the sum of 3 million, being arrears of salary for for the month of October, November, December 2021, succeeds based on the incontrovertible fact and evasive reaction to the claim by the defendants. Relief D for 109 million, being the claimant salaries for the remaining 9 years and 1 month provided for in the irrevocable management agreement cannot be granted. This is because an employer does not guarantee a job to an employee until the duration of his employment. See the cases of Springbank Limited, PLC, and Babatunde Okweme and Civil Service Commission, Edo State. Relief E for damages in the sum of 10 million cannot be granted because damages of whatever kind, general, exemplary, etc., are a function of liability. And since the liability of the defendant is not established in this case, the claimant will not be entitled to the award of the damages. See the case of Union Bank and Saures. Similarly, relief F for legal fees in the sum of 5 million cannot be granted, as the claimant cannot foil his cause of litigation on the defendant in the absence of any express agreement to that effect. This is the case of SPDC and Okwenabi. We are left with the defendant's counterclaim praying for a declaration that the claimant mismanaged, misappropriated, or diverted the first defendant's money amounting to at least 50.5 million, directing and an order directing the claimant to return the sum of 50.5 million and to pay the sum of 200 million as general damages. A counterclaim for all intents and purposes is a separate, independent, and distinct action, and the counterclaimer must prove his case before obtaining judgment. I cited Ogbuna and AG Imo State, Brigg and Stone, and ACB, Dabob and Kolo, and Jerick and Union Bank, to mention but a few. The law is that the claimant, that is the counterclaimant in this case, have the burden of proving their entitlement to the claim and the contour of the claim. To prove an entitlement, the claimant must refer the court to the exact provision of the law, instrument, or document that confers the entitlement. See Mohammed Dungus and ENL Consortium. In other words, it is the duty of the claimant to plead only such facts and materials as are necessary to sustain the relief sought and adduced to prove same. This is Gabriel, Active and Cable Metal. And because the claimants are predicated on diversion, mismanagement, and appropriation of funds, the counterclaimant must go further to prove that the funds were dishonestly misappropriated for his own use. For the use of the defendant. See Alabian State, Wekedi and Police Commissioner, Nasir Isa and Federal Republic of Nigeria, Nasir Uyaya. It goes without saying that the defendant counterclaimant in this case have proved both entitlement and the quantum of the claim in view of the fact that all the alleged diverted or misappropriated funds came from the Senate bank account numbers 10865778, and that is Exhibit DW2, and 1017824632, that is Exhibit DW1, belonging to the first defendant. It is, however, improving the funds that the funds are dishonorably misappropriated for the claimant use that the counterclaimant is found wanting. I've carefully gone through the breakdown of the monies allegedly misappropriated in paragraph 21 and 230 of the joint statement of defense and counterclaim reproduced in pages 7 and 9 of this judgment. And I can only find one transaction that can attract the element of dishonest misappropriation for the claimant use. That is the expenditure of 25.5 million. The expenditure of 25.5 million on 13 October 2021. In his response to this, the claimant admitted to making the payment to himself with the approval of the second defendant as his consultancy fee of 5% for securing the 510 contract awarded to the first defendant for the construction of the Miatok Ekiram Biarom Road. Whether or not the claimant is entitled to this payment is left to be seen, as his claim of securing the contract for the defendant is not only disputed, but is unproven. There is nothing before the court to show that the claimant actually secured the road contract for the first defendant. Going by clause 2 of the irrevocable consultancy agreement, that is CW6, the claimant shall be paid 5% of the total contract sum secured and facilitated for the first defendant. It is also equally true that by virtue of clause 4 of this same agreement, the payment of this 5% fees shall be paid upon the signing of the contract with a grace of not more than 14 days. By clause 5, the fees are payable in 2 tranches of 50%, with the first tranche to be made not more than 14 days after the contract award or bank guarantee, and a postdated check of not more than 60 days for the balance. From the records, the road contract was awarded to the first defendant on 10th September 2020, while the purported payment of the 5% was on the 13th October 2021, a period of over 1 year. No explanation was given for the failure to comply with the elaborate provisions of clause 4 and 5 of the irrevocable agreement. The last time I checked, 5% of 500.3 million is 25.51817,203 and not 25.5 paid by the claimant as fees. So the sum of 25.5 million is the only amount which can be traced to the claimant for his own use and therefore refundable to the counterclaimant. And so far, and all. From all I'm saying, both the main claim and the counterclaim succeed in part in that the defendant is to pay the claimant the sum of 3 million being arrears of salary for the 3 months, while the claimant is to refund the sum of 25.5 million appropriated for personal use to the defendant. If 3 million is deducted from 25.5 million, you will have the balance of 22.5 million, which goes to the defendant. Accordingly, for the avoidance of doubt, it is hereby ordered that the claimant shall refund the sum of 22.5 million to the defendants within 30 days from today. I make order I make no orders to cause judgment entered accordingly. This
As
is
the
the-
court, please. As the court, my Lord, I'm sorry for having come late. My Lord, I'm sorry for having come late. The network was bad here, sir. I'm sorry, sir. My name is O.R. Oniyeson, sir. O.R.
Let me,
Oniyeson.
let me record the two of you came late.
I'm sorry about that, sir.
I'm so sorry, Your Lordship. My name is Assam for. May I announce my belated appearance for the claimants?
You are welcome.
Thank you, Your Lordship. Thank you, my
At
Lord.
what point did you join?
Hello, my Lord.
I said, at what point did you join?
My Lord, I was able to join just now, but I had the concluding orders made by my Lord,
Which?
ordering the claimants to refund to the defendants the sum of 22.5 million naira, sir.
Good.
My Lord, my name is O.R. Oniyeson for the defendants, counter claimants.
I want to record you came late.
My Lord, I'm sorry about that, sir.
Assam.
Yes, my Lord. For the claimant, I joined just at the while my Lord was analyzing the evidence, was evaluating the evidence, my Lord.
So what is your take? You are not happy, I'm sure.
Yes, Your Lordship. Well, we submit to the wisdom of my Lord and would advise our client accordingly.
I'm sure you go upstairs. I hope you have leave to go upstairs.
I'm so sorry, Your Lordship.
I said, I hope you have leave to go upstairs. Lift, not leave.
Okay. As the court pleases.
Yes. So in the absence of any other business, I sign off and say bye-bye to you.
We are grateful, my Lord. We are grateful.
Thank you very much, Your Lordship. Yes.
Thank God. I won that case. Thank God. I won it. I won it. I won it.